We'll begin our meeting of the Falls Township Board of Supervisors. It's about 3 minutes after 7 on January 18th. We'll begin with our salute to the flag, please. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Mrs. Pullen, can you take the roll, please?
Here.
Mrs. Wisłocki. Mr. Harvey.
Here.
Mr. Dent.
Here.
Mr. Snipes.
Here.
Okay, thank you. You can see by tonight's agenda, which I'm looking for now, that we're going to begin with some presentations from our Park and Rec Director, I believe, right? Mr. Bill Reese, in regards to the holiday house decorating contest which just passed. Is that it, Mr. Gray? I don't know if I didn't want to steal your thunder.
Yes, tonight we have Mr. Bill Reese representing the Park and Rec Department, who will be providing certificates and awards to winners of the 2010 Holiday Decorating Contest.
Okay, Mr. Reese.
Thank you, Mr. Gray. Good evening, everyone. It's a pleasure to be here again, especially tonight, to present these special awards. As you probably have known, we've been having a house decorating contest for the last few years, and this year we had, I believe, 11 nominations, and 5 houses were selected. So we have certificate of excellence to give out, and also gift certificates. I know I believe the 4th place and 5th place people are not here this evening, but we do have our 1st, 2nd, and 3rd place winners. But I'd like to read all of them, if that's okay. 5th place was Richard Feldman, who lives on 27 Lower Morrisville Road. And this certificate would be awarded to Richard Feldman for 5th place in the Township of Falls 2010 Holiday Spirit House Decorating Contest. So we'll make sure Richard gets this. He's going to make arrangements to come in. So we can give him a round of applause. That would be wonderful. Our 4th place winner is John Burton. I don't believe John's here. No, okay. 429 Austin Circle for 4th place in the Township of Falls 2010 Holiday Spirit House Decorating Contest. John Burton, 4th place. Round of applause for John. Third place, Certificate of Excellence, goes to Dean Weinberg of 5th Evergreen Lane for 3rd place in the Township of Falls 2010 Holiday Spirit House Decorating Contest. Come on up, Dean. Second place goes to Lawrence Newell, Certificate of Excellence for Lawrence Newell of 2006 Devon Road for 2nd place in the Township of Falls 2010 Holiday Spirit House Decorating Contest. Lawrence? Thank you very much. And our 1st place winner, Certificate of Excellence, goes to Milton Worrell of 257 Elderberry Drive for 1st place in the Township of Falls 2010 Holiday Spirit House Decorating Contest. We have 3 winners. Come on out. We'll get a picture taken real quick. Matt's in the back. I think he's going to come out and take a quick picture. Yeah, family.
We'll do it this way. We'll get up. Get out of the way, maybe. Oh, wait, he's doing it that way. Which way is he doing?
Wow. Are you going to get in it? No. Oh, okay.
Okay, we're good.
Thanks, guys.
Mr. Harvey, I could just mention, we did have 5 sponsors who donated gift certificates from our area shops. That's Adriatic Pizzeria, V&S Pizzeria, the Original The Originals Italian Pizzeria Restaurant, Di Lorenzo's Restaurant, and Papa John's Pizza.
Okay, thank you very much. Okay. And I think Mr. Reese and also the people here at the Township who helped carry that off every year. As I said, around Christmas time, it's always nice to recognize those people that make the holidays a little bit brighter for us and spread some Christmas cheer. Okay, we're moving on with our agenda. Item number 1 is certificate of appropriateness for 93 Main Street as for a roof replacement. Mr. Gray?
Yes, as mentioned, this is a certificate of appropriateness for 93 Main Street, Fallsington, PA, consisting of the replacement of the existing slate shingles with new asphalt shingles. This has been approved by the Historic Review Board at its meeting on January 6th. The owner of the property is Jeff Lazor. At this time, the board is asked to consider approving the certificate of appropriateness.
Okay, thank you. Let's see, are there any comments or questions from board members? We have some photos here of the property. Mr. Zupka?
No, I have none.
Mr. Snipes?
Yeah, this says replacing the slate with asphalt. I'm assuming they're doing it for cost. Replacing a slate roof is pretty expensive, even though it'll give you more life. So I assume if that's what they're doing, I understand that, and Historic Review Board has approved it, so I'm in favor of it.
Okay. Mr. Dents?
No questions.
No, I don't have any either. Mr. Laser, I'm presuming? Okay. Any public comment needed? I see no hands. Okay. Is there a motion then to approve the certificate of appropriateness?
So moved.
Seconded.
A motion made and seconded. All in favor? Aye.
Aye.
Opposed? Okay. Thank you, Mr. Laser. Good luck. Okay, second item on our agenda is a conditional use hearing for a cellular phone equipment by T-Mobile. This is located at a tower at 1000 New Ford Mill Road, tax parcel number 13-50-2. We're going to open up the conditional use hearing. We have to have a motion. Mr. Clark, anything you want to add before I open?
Once the hearing is opened, Mr. Chairman, I will just read the applicant's information into the record and then inform applicant's counsel of the procedure regarding this matter.
Okay. Is there a motion to open the conditional use hearing for this matter?
So moved.
Second.
All in favor? Aye.
Aye.
Opposed? Mr. Clark?
Thank you, Mr. Chairman. This is a conditional use hearing. The applicant is T-Mobile Northeast LLC. The property is tax parcel number 13-47-128, incorrectly noted in the application as tax parcel number 13-50-2, Township of Falls, Bucks County, Pennsylvania. This is an application requesting conditional use to allow the co-location of a wireless telecommunications facility on an existing tower within the existing compound located at 1000 New Ford Mill Road. The applicant is represented by Nicholas Cucci Esquire, who is present this evening. Mr. Cucci, it is the procedure of the Board of Supervisors in conditional use hearings involving co-locations. In order to expedite the process, we would ask that you introduce the application, give a brief overview of where it is located, and a brief overview of the application. Mark any exhibits that you want made part of the record, and then to identify your witnesses and give a brief synopsis of what they would testify to if they were called upon to testify. After you've completed that synopsis, we would ask that you bring your witnesses forward. You have them sworn individually, and then individually you ask them if they heard your synopsis and they agree with it. At that time, you will make yourself available you and your witnesses available for questions from the board and from members of the public who are requesting party status. Do you understand this procedure?
Yes, I do, Mr. Solicitor. Thank you.
You may proceed.
Thank you very much. Prior to proceeding, I actually have pre-marked exhibit packets, if I may hand those out at this time. Thank you.
Thank you.
Thank you.
Thank you. That said, good evening. My name is Nicholas Couchet. I'm here on behalf of the applicant, T-Mobile Northeast LLC. As noted by the solicitor, we are looking to co-locate a telecommunications facility for T-Mobile at the previously referenced address, which is 1000 New Ford Mill Road. That property currently contains a telecommunications facility which consists of a 150-foot monopole within a fenced compound. There is one carrier on that pole as it stands. T-Mobile has a significant gap in coverage in this area and is looking to install its antennas on the 150-foot monopole. There would be 9 panel-style antennas, 3 per sector, at a height of 140 feet. That is to the center line of the antennas. Therefore, we're not requesting an extension of the tower of any kind. Also, we are proposing the placement of 3 equipment cabinets within the existing fenced compound on a new 10-foot by 20-foot concrete pad. Therefore, there would be no expansion of the existing compound. As noted, we are seeking conditional use. We received a unanimous recommendation of approval from the Planning Commission, I think it was last week. We also received a revised, let me back up. We had submitted revised plans that were dated December 7th, I believe. And we received a revised letter from the Township engineer. I believe the board has it. If not, I have extra copies. All of the issues in the letter are will complies for T-Mobile, but we can go through if the board would like at the end of the presentation specifically. That said, originally, just so the board is aware, the Falls Township Zoning Hearing Board, by motion dated December 13th, 2005, granted a height variance to Nextel to allow the tower to be 150 feet in height. That is marked as Exhibit A2 in your exhibit packets. This evening, I would be presenting 3 witnesses to the board. Our site acquisition consultant, our radio frequency engineer, and our project engineer. And if I may, I would go ahead and summarize the testimony of each of those witnesses at this time. Our site acquisition consultant this evening is Mr. Michael Fahey. He would testify primarily that T-Mobile looks to co-locate on existing structures whenever possible, which is also encouraged by the Falls Township zoning ordinance. He would testify that T-Mobile has the owner's authorization to proceed with this application, and a lease has been executed, directing the board's attention to Exhibit A3, which is a site lease agreement redacted as to its financial terms. He would note that here the monopole is an existing structure within the area that is currently lacking reliable coverage, directing the board's attention to Exhibit A4, which is an aerial view of the subject property and fenced compound as it exists. He would testify that if T-Mobile's facility were to remain unused for a period of 12 consecutive months, T-Mobile would remove its antennas and equipment within 6 months of the expiration of the 12-month abandonment period in accordance with the Township zoning ordinance. Finally, he would testify that T-Mobile will provide a certificate of insurance evidencing the general liability coverage in a minimum amount of $3 million per occurrence and property damage coverage in a minimum amount of $3 million per occurrence as per the Township zoning ordinance. That would be the sum total of Mr. Fahey's testimony this evening. My second witness, as noted, would be our radio frequency engineer, Mr. Bassem Iskander. Mr. Iskander would testify as to his credentials in the field of radio frequency engineering, and note that he has testified in numerous municipal proceedings for telecommunications facilities, directing the board's attention to Exhibit A5, which is a copy of Mr. Iskander's current CV. He would testify that T-Mobile is licensed by the FCC, directing the board's attention to Exhibit A6, which is a copy of T-Mobile's FCC license for this market area. And that under this license, T-Mobile is required to provide what is called reliable coverage. Reliable coverage is when a user is able to initiate and maintain a call without it dropping, obtaining a busy signal or going directly to voicemail. He would testify that this site is needed for coverage reasons, as there is not current reliable in-building coverage in this area, directing the board's attention to Exhibits A7 and A8, which were propagation plans that were prepared by Mr. Iskander, noting the white areas or gaps in coverage, and the site on air would be the green area propagating. That would be the reliable coverage that would be gleaned from this site, and that would be in Exhibit A8. Part of his testimony would be that the facility complies with all the antenna power levels and for maximum permissible exposure, directing the board's attention to Exhibit A9, which is an RF emissions compliance report, which demonstrates that the levels that will be put off from this site are well within the acceptable FCC levels, noting to the board that this report takes into account not only T-Mobile's equipment and antennas, but also takes into account the existing antennas of Sprint. So it's in the aggregate, and that amount is well within the FCC standards. He would testify that the proposed height of the antennas is the minimum relief necessary to provide reliable coverage. And lastly, he would testify that the proposal complies with all applicable state and federal regulations, and that the facility will not cause radio frequency interference with other communications facilities in the area or electronic devices such as televisions, home computers, radios, things of that nature. That will be the sum total of Mr. Iskander's testimony this evening. Finally, I would be presenting Mr. Mario Calabretta, professional engineer on this application. He would testify as to his credentials in the field of telecommunications site design, and that he has testified in numerous municipal proceedings for telecommunications facilities, directing the board's attention to Exhibit A10, which is a copy of Mr. Calabretta's most recent CV. He would testify that the plan accurately depicts what is being proposed this evening, directing the board's attention to Exhibit A11, which is a copy of the most recent plan dated March 29th, 2010, last revised December 7th, 2010. He would testify that the installation, that the proposal of T-Mobile is the installation of a telecommunications facility of the property consisting of the addition of 9 panel-style antennas, 3 per sector, at a height of 140 feet. That is, again, to the center line of the antennas on the existing 150-foot monopole. Further, he would testify that T-Mobile proposes the placement of 3 radio equipment cabinets within the existing fenced compound on a new 10-foot by 20-foot concrete pad. As noted previously, the applicant proposes no extension of the tower or expansion of the existing compound. He would testify that parking will be provided by a designated space within the fenced compound, as is required by the zoning ordinance, and the plans will be revised to show the parking spot in the compound. He would further testify that he is familiar with the structural requirements and that the monopole can structurally support the antennas as proposed, directing the board's attention to Exhibit A12, which is a copy of a structural analysis prepared by Velocitel Solutions dated June 11th, 2010. He would also note that the facility will be designed in accordance with all applicable safety and industry standards and will comply with all applicable building codes. He would testify that the site will be unmanned and would only require monthly maintenance visits at most. He would testify that the proposal requires no continuous lighting, no signage, no water, no sewer, and will produce no noise. He would testify that since there is no increase of the height of the monopole, no FAA registration is required. He would testify that the use will not impede the normal and orderly development and improvement of the surrounding properties for uses permitted within this district. And finally, he would testify that the use will have no impact on traffic congestion on public streets. That would be the sum total of Mr. Calabretta's testimony this evening. I would ask then, Mr. Solicitor, if I'm correct, for my witnesses to come
That would
forward.
be correct.
Gentlemen, could you please each state your name for the record?
Mario Calabretta, M-A-R-I-O, C-A-L-A-B-R-E-T-T-A.
Mr. Fahey, did you have an opportunity to listen to my summation of your testimony this evening?
Yes.
And would you augment any portion of that testimony?
No.
And would you adopt it as your own?
Yes.
And
Mr. Kuchek, just...
Yeah, I'm sorry.
Just have your witnesses move next
Oh,
to you
Closer to the
by
mic, just so they're on the microphone.
No. With each one, if you can step up and stand right next to Mr.
Yeah,
Kuchek. so
one
we
at a time,
we
just
can
so-
hear you.
We can't hear you at home unless
Yeah,
you
we need
stick
the
it on
microphone. It's all, everything's recorded, so thank you.
would you like me to go through?
If you don't mind, I'd probably, yeah,
No,
thank
no,
you.
Not at all. Mr. Fahey, did you have an opportunity to listen to my summation of your testimony?
Yes.
And would you augment any portion of that summation?
No.
And would you adopt it as your own?
Yes.
Thank you. Mr. Iskander, did you have an opportunity to listen to my summation of your testimony this evening?
Yes.
And would you augment any portion of that testimony?
No.
And would you adopt that as your own?
Yes.
Mr. Calabretta, did you, sir, have an opportunity to listen to my summation of your testimony?
Yes.
And would you augment any portion of that summation?
If I could simply clarify, the number of cabinets at the base of the structure, the plans show up to 6. There's physically room for up to 6 cabinets. So I would just like to say, will not all necessarily be installed at one time, but they're physically a space, and we do show up to 6 cabinets. So that's the only thing I would add to what you'd already said.
Other than that, would you adopt the rest of the testimony as your own?
I would, yes.
And that would be all I have for these witnesses, so if the board has any questions.
Okay. All right, we'll turn to board members for questions either for Mr. Couchet, Mr. Fahey, Mr. Iskander, or Mr. Calabretta. Mr. Zupka, any comments or questions?
Just want to be sure, this is for cohabitation on an existing tower that has, I guess, a few years ago approved to be 150 foot instead of the 120-foot limit.
That is correct.
Okay, thank you.
Mr. Snipes?
Yes, Mr. Couchet, the actual contract with T-Mobile is going to be working with whom? TowerCo? The land and tower is owned by Waste Management, is that correct? Or describe the relationship between the owner and then the other entities involved.
Of course. Actually, Mr. Fahey can handle that question.
The owner of the land, the owner of the ground is Waste Management. TowerCo leases the ground compound from Waste Management, and TowerCo owns the tower itself. T-Mobile intends to co-locate on that tower.
And so is contracting with TowerCo?
Correct.
In essence, right.
Correct.
Okay, thank you. The only other question I have is, we frequently get these requests for co-location to extend the service provided by the companies. The question I have is the distance from the tower the only issue involved with reception? In other words, do we need to cover the landscape with towers at so many intervals? I mean, the only concern I hear from residents is the number of towers and how many and those kinds of questions. So is this simply a question of your proximity to a tower in terms of reception, or is there topography, other questions involved?
I would turn that over to Mr. Iskander.
In this particular case, it's proximity to a tower.
Okay.
There are other issues that are normally staged in an application, but in this area, there's simply no tower nearby. The closest tower is over 2 miles away.
Okay.
And other than that, the terrain is flat. There's no high structures. There's not a lot of trees. There's no trees, or maybe just a few. So it's just where you are from an existing tower that has T-Mobile service on it.
So in other areas, buildings, trees, mountains might get in the way, you're saying?
Correct.
Okay. So if you were to complete the service in this area and have service available to everyone, there would need to be more towers placed at more frequent intervals. Is that true?
Yes, and depending on the obstacles that a signal would have to go through to get from the antennas on a tower to a customer, that depends on the coverage footprint that you obtain from any particular site.
Thank you very much. That's all I have, Mr. Chairman.
Okay. Mr. Dents?
Mr. Calabretta stated that 6 cabinets could fit at the base in the compound. Is that a total of 6? In the entire area, or just 6 that T-Mobile would have the option of using?
The compound itself is very large, 100 feet by 100 feet. T-Mobile's lease area within that compound is roughly 10 by 20, 10 feet by 20 feet. In that 10-foot by 20-foot area, a total of 6 cabinets could be installed.
Okay.
That still leaves room for other
Carriers.
space, other carriers, if they would choose to come
So
to
how many
this location.
pieces of equipment do you need for your 9 antennas that you're proposed to put on there?
Well, some sites can run with as little as 1 cabinet. They can go up to 6, and it really is an issue of how many calls a particular site needs to handle. So in this particular case, not just this case, T-Mobile generally looks for an area where they could put 6 cabinets if and when they ever needed to expand their coverage or their service. They would already have a 10 by 20-foot concrete pad in this case where they would put just a second or a third or a fourth up to 6 cabinets.
Okay, thank you. That's all I had.
Okay. I did note that in one of the review letters, I believe it was traffic planning and design review letter, there was an issue that was raised regarding the site distance coming out of the driveway and vegetation obscuring that. And I've had a talk with Mr. Gray, our township manager, who I think has relayed that information to our code enforcement officer that obviously the vegetation is going to have to be cut back, but it's not necessarily your responsibility. It's the owner's responsibility, which is waste management. So we'll make sure that's done. I do see that's an issue in here. I didn't know if any board member was going to be looking at that as they looked at the review letters, but that's something that we're going to handle with waste management. In terms of comments or questions from professionals, Mr. Clark, do you have any?
Only, Mr. Chairman, Mr. Kuche, you have the T&M Associates letter of January 11, 2011, is that correct?
Yes, that's correct.
And you will comply with what is listed in the T&M review letter?
Yes, we certainly will.
And you have the Traffic Planning and Design review letter of December 23rd, 2010?
Yes, I do.
And you will comply with the comments in that review letter?
Yes, sir, we will.
I have nothing further, Mr. Chairman.
Okay. Mr. Sullivan, comments or questions from you?
Not at this time, thank you.
Okay. All right. Having heard the testimony and had questions, is there a motion to close the conditional use hearing at this time?
So moved.
Second.
Motion made and seconded. All in favor? Aye.
Aye.
Opposed? Okay. In terms of public comment, is there any public comment needed? I see no hands. Okay. We've heard the testimony, had our chance for questions, and open it for public comment, and having none, our professionals have also had their input. Is there a motion at this time regarding the conditional use hearing for T-Mobile Northeast LLC at 1000 Newford Mill Road, tax parcel number 13-50-2?
Yes, Mr. Chairman, I move that we approve the conditional use for T-Mobile Northeast LLC, the co-location we've been discussing at 1000 New Ford Mill Road, tax parcel number is this the right tax parcel number, 13-50-2?
13-47-128.
13-47-128.
I'll second the motion.
All right, motion is made and seconded. All in favor? Aye.
Aye.
Opposed? Okay, thank you,
Thank you all
gentlemen.
very much.
Thank you.
You're welcome.
Appreciate it.
This back?
No. Thank you, no.
Of course not.
Yeah, Jack knows that. Yeah, that's what he just said.
Oh, he did.
Yep, thank you.
Yeah. It's a stipulated agreement, so.
All right, we'll move on with our agenda. Item number 3, which is a final land development for CVA at 110 Central Avenue. Mr. Gray?
Yes, as mentioned, this is a final land development for CVA. They are proposing a 3,800 square foot warehouse building. They are located at 110 Central Avenue. Tax map parcels 13-5-202, 13-5-207, and 13-5-208. Representing the applicant tonight is Carolyn Edwards.
Evening, Ms. Edwards.
Evening.
you don't mind just giving us an idea of what this project entails. Obviously, we know, but in terms of the public.
Absolutely.
And then addressing, if you don't mind, the review letters from Traffic Planning and Design as well as from T&M. And I believe there was also a letter from the
Fire Marshal.
Fire Marshal. Yes, thank you.
Yes, I represent Mr. and Mrs. Campalone, who are the legal owners of this property. The property is located at 110 Central Avenue, which is a private roadway which runs behind the Pets Plus building. If you go down Spencer, which ties into Business Route 1, and then Central Avenue comes off of Spencer. The total site is made up of 3 tax parcels, as noted, totaling just under 14,000 square feet. The zoning of the property is HC, which is highway commercial, and the property is currently not being used. The background on this, just for the board's, to refresh the board's memory on this, the property went through zoning hearing board hearings because of variances that were required because the property is much smaller than the minimum lot area in the HC district. There was eventually a stipulation entered into between the Campalones, the Township, and the Zoning Hearing Board, which provided for a plan design almost identical to what you see before you today. There's a slight variation in the parking, but as far as building size, building location, and whatnot, the setbacks, those are all in conformity with the stipulation plan. The property is proposed uses as a warehouse, which again is in conformity with the stipulation. And that stipulation is referenced in the Township Engineer's review letter. We do have the review letters noted, the T&M Associates letter dated January 11th, 2011, the TPD letter of January 14th, the Fire Marshal letter of October 18th, 2010. There are really very few issues in those letters. The majority of the comments relate to the waiver requests. Those waiver requests are similar to the application to the Zoning Hearing Board in that there are items that don't make sense for a property of this size. They were aimed more at a property that would be in conformity with the lot area, curbing and that sort of thing, which in the context of this property located on a private road aren't really necessary. I'm prepared to go through the review letters if that's the way you'd like to proceed.
If you could just, address the waivers each individually and just
Sure.
the reason for asking for them.
Absolutely. The first, I'm going to go through, I believe I'm doing this in the order that is in the T&M Associates letter. The first waiver request is from 191-34D1 of the subdivision ordinance requiring a 500-foot clear sight triangle from the driveway. That is not possible to provide for this property because of the Central Avenue ends in less than 500 feet and Spencer Avenue, the intersection. So what we've been asked to do is to provide the maximum possible sight distance shown on the plan, which we will do. So that's a will comply, but we are requesting a waiver from the 500-foot requirement.
Right.
The second waiver request relates to curbing along the driveway and curbing along the frontage of the property. And that's section 191-36D and 191-62B of the subdivision ordinance. It was provided on the stipulation plan that the curbing would not be required. The discussion at that time related to currently there's no curbing along that entire roadway, so it would possibly be a traffic issue if someone was driving along an uncurbed roadway and suddenly there was curbing that could possibly become an impediment, and also stormwater flow would be changed. The TPD did not have any issue with no curbing from a traffic perspective. The next waiver request is 191-36D, a request for a 25-foot radius for the driveway. The stipulation plan showed a 15-foot radius. This plan shows a 20-foot radius. While TPD did not have an issue with the radius, the fire marshal was concerned about the ability to have emergency vehicles access the site. So what we've done, our engineer has taken a look at it. He's proposing a modification of that. I'm not sure, does it quite get us up to 25-foot radius? This is Mr. Young from Gilmore Associates. He's our engineer.
Hi, good evening. I have a color handout that would show you. We can actually put in a broken back curve. It's not really a geometrically correct design, but if we start the curve earlier, we can accommodate.
Thank you.
You know about this? No. This is new to you?
Thank you.
It's probably okay.
What I would like to do, even though we are providing something which we believe would be the 25-foot radius, what I'd like to do is maintain the request for a waiver in case that doesn't come through at exactly 25, so that we don't have to come back before this board for that sort of an item. The next waiver request is Section 191-37B, which relates to the requirement for 15 feet of open space between the building and the parking area and 12 feet of open space between the parking area and the property line. This waiver is made necessary due to the constraints of the size of the site. The parking location, as I indicated, is substantially the same as that shown on the stipulation plan, which was approved by the board at that time, as well as the zoning hearing board. So we'd request a waiver from that requirement. We're just, if you can see the site, there's...
You're going to have, I'm sorry, miss, you're going to have to take the microphone when you walk, sorry. Thank you.
If you can see the site, just the way the building is, the parking is, there's just not a whole lot of ability to move and maintain that open space between the property line and the parking in the building. One of the concerns when we were coming through the zoning hearing board with the approval at that stage was maintaining a setback at the rear, from the rear. So to do that, some of the other areas need to be squeezed. The next waiver request is 191-37G1, which requires curbed planted islands at the end of the parking row. Again, first of all, this isn't really a public parking lot where that is more commonly seen. The TPD review letter said that they didn't see any issue with not providing that. The next waiver request is from 191-39G, which requires sidewalks along the frontage. We included that on the plan as a waiver request. However, because that was included specifically in the stipulation, I don't know if we really technically need a waiver from that, but we did include it on the plan, so I wanted to mention that to the board. I don't know if Mr. Clark has any thought on that, or Mr. Sullivan.
I'm looking at the stipulation right at the moment. Ms. Edwards, if you can perhaps direct me to where that is in the stipulation.
D, paragraph D, under terms and conditions.
In paragraph D of the stipulation, it indicates that no sidewalks, street trees, or roadway improvements shall be required along the frontage of the property.
Okay.
So Ms. Edwards is technically correct. While they're asking for this in a waiver, it has already been agreed upon by the township back when this matter was resolved back in '08.
Right. Okay.
The next waiver request is 191-52.1B4, relating to disturbance of woodlands. This entire site is wooded. The maximum disturbance is 50%, but that is considering the size, the minimum lot area in the HC district, which is, I believe, 30,000 square feet, more than twice the size of this site. So we're requesting the ability to disturb all of the woodlands on this site. And again, this is consistent with the stipulation plan.
Mm-hmm.
The next waiver request is section 191-72C2, which requires that the plans show details of owners and improvements and things within 200 feet of the property. We're requesting that we be able to provide only 100 feet. The nature of this development is not such that the impact is going to be large. It's one building, one parking lot on a private road. So we think that it would be appropriate to just limit it to 100 feet. We're requesting a waiver from the slope of storm pipe on the site. The ordinance requires it to be 0.5%. We are requesting to provide 0.15%. Let me just describe the situation. There's an existing storm pipe on the site, and my understanding is that currently that does not have a positive slope at all. It's basically not working. We're proposing to replace that so that it does work, but because of the flatness of the site, there are limits to how we can do that. So 0.15% is what we can get. The second request is similar. It relates to the coverage of that pipe. The ordinance, and we're talking about the stormwater management ordinance here, requires 18 inches of coverage, and we're proposing 6 inches of coverage. But in return, we're going to be providing a pipe that is much stronger than the standard requirement. I believe it's called a Class 5 pipe. Do you want to describe what that is?
All it is a little bit thicker wall and more reinforcement in the concrete.
Okay. Okay.
And those are the waivers that we're requesting.
Okay. All right, we'll turn to comments or questions from board members. Mr. Zupko?
Not at this time. If you come back to me, please.
Okay. Mr. Snipes?
Yes, Mr. Chairman. The first couple waivers seemed to make sense, and the longer we went into the long list of waivers, the more questions I had, but I'm going to listen to what other board members have to say about some of the waivers that have been requested. I understand that a lot is small, but I don't want to look at our requirements as sort of that they're not important. So, but I'm willing to hear what other board members have, and I'll have to say, and I'll have more questions then.
Okay. Mr. Dents?
The lot is small, it's in an odd location, too. My only question is for Mr. Sullivan about the stormwater management and this pipe. There's no issues with that, you see? Or any comments on that?
No, as the applicant stated, the pipe that's there today doesn't work, and they're actually going to replace that one and make it work the best that they can.
It still won't comply, but you like the way they're doing it?
It'll work. It's not ideal because your pipe slope, minimum pipe slope, is for maintenance and self-flushing, but it'll work.
All right, thank you. That's all I had.
Okay. Staying with Mr. Sullivan, looking at this revised plan Mr. Young just gave us regarding the radius for the driveway, do you have any issues or concerns with that at this time?
No, I don't particularly have any issues with it, but I would say that's up to the fire marshal to make sure that emergency vehicle access is acceptable with this new configuration.
Okay.
If I can just note, the TPD letter did make mention of the fact that we had submitted a template showing that emergency vehicles could access the site.
Right.
So there is some evidence that it can. We're trying to address the fire marshal's concern so that we can provide the best possible scenario.
Okay. Yeah, I know that it is an odd situation. It is a very small lot, and usually something that's highway commercial is a much larger piece of property. For example, the land this building sits on, and the property you're talking about, the building you're talking about building, I think would fit inside this building a couple times. So it's not a very large building, and I if you said it, I apologize. I missed it. The purpose of the building, just warehousing, basically?
Right, warehousing.
Okay, all right.
The CVA site across Central Avenue.
All right, it's a construction company, essentially,
Yes.
correct?
Mhm.
Okay. All right, so it's not a facility that's going to be getting visitors in terms of customers or anything else. It's basically a warehouse for a property across the street that's already in operation.
Yes.
That being said, I mean, obviously Mr. Sullivan's already commented on the pipe slopes. In terms of the woodlands, it's not exactly like we're clearing, huge acres of African rainforest or something here. This is, very, very small area of trees that are going to be cut down, and none of the trees are incredibly large. I was out there today and looked at it, relatively small diameter trees. Obviously, it doesn't make sense to have curbed planting islands at the ends of a parking row because you only have 2 parking spaces for people that are employees. In terms of what we just talked about, what Mr. Sullivan just mentioned with the fire marshal, question for the solicitor, in terms of approving this, if what I guess stipulations can we put on it regarding letting our fire marshal have a look at this revised plan? Is there anything we can do, or are we sort of, if we approve this tonight, this, it doesn't really matter what he says anymore?
Well, initially, Mr. Chairman, the fire marshal was involved in the discussions regarding the stipulated settlement back in 2008. Many of the concerns that the township had regarding this original design were raised by the fire marshal back in 2003. We were concerned about emergency access. I believe that the plan that has been submitted and the plan that has been reviewed by Mr. Sullivan is, again, consistent with what is in the stipulation. If there's something new that's been presented this evening, and I think, unless Mr. Sullivan disagrees, if the fire marshal is comfortable with this change and it can be done, I think the applicant is willing to do it. If it can't be done, I think the fire marshal has already signed off on what was there originally. So.
Okay. All right. Okay, Mr. Dents?
This is the drawing that shows the fire truck and the trash trucks. Was that with your new radius that you gave us tonight, or that's on the original 20-foot?
That's the 20-foot radius.
Okay.
Thank you.
Mr. Zupka?
In some of the information I was originally presented with, it talks about, without the curbing, it could be an issue with water drainage, and since you already brought up the fact of, it's not, the drain that's there right now probably isn't working at all. Taking all the trees down, the 50% of the woodlands, although I've looked at it, I wouldn't really consider it a woodlands, but again, we're taking away growth that might actually slow and help absorb water, and with the amount of rain we've been getting all around the world, I'm not sure that's the best idea. But my main concern is this 25-foot turning radius, even with showing the new templates for both fire truck and trash truck on there. Somewhere, I think in traffic planning design, they talked about on-street parking, and if you go down there and you look, well, if people are parked on the street, regardless of the turn radius, we're going to have trouble with getting the emergency equipment in there, and I think it would be hard to control. And we show that the 20-foot radius with the vehicle making the turn from the immediate side of the street. And well, if he can't even get there, or now we don't have curbs and it's up. Getting up into the property with some of the heavier equipment that we use for fire equipment and even the trash trucks. Unfortunately, I have a real problem with it. I would want to see the 25-foot turn radius, but on the other hand, just the parking on the street, and I'm not a real fan of all the waivers. I can see why some of them are there, but it's almost like there's too many waivers that this might not be the right spot for this project.
Okay. All right. Mr. Snipes, you have indicated earlier maybe you'd listen to other board members, and not know if you have any comments at this time or not.
No. No more.
Okay. All right. Is there any public comment needed? I see no hands. Mr. Clark, the term stipulated agreement has been used several times this evening. Would you just give us an idea? It's something new, really, for us, and I don't think I've ever had to deal with a stipulated agreement before. What exactly does that mean?
And it is something new, Mr. Harvey. In looking over in preparation for tonight's hearing, I cannot recall the last time we dealt with this issue. The Campolones originally submitted an application to the Zoning Hearing Board back in May of 2003. By the time it finally went to the Zoning Hearing Board at the end of 2003, it was denied by the Zoning Hearing Board. The Campolones filed an appeal, and we, the Township, joined that appeal. Sometime in the early part of 2005, the Court of Common Pleas sent it back to the Zoning Hearing Board, essentially telling them to take further testimony on certain issues. Testimony was taken in front of the Zoning Hearing Board on 2 occasions, in the end of 2005 and again in 2006. And during this time, Ms. Edwards and myself and Mr. Toadvine, on behalf of the Zoning Hearing Board, began to enter into discussions about potentially trying to resolve this matter without the need for further hearings before the Zoning Hearing Board and without the need for this going back up to the Court of Common Pleas. One of the reasons we did this is because we felt that in some of the decisions that had been made when this matter had been remanded gave the Township some concern that if this did go to a final decision in front of the Court of Common Pleas, that we may not be able to get some of the things that we wanted. We then went through a process from the middle part of '06 until I think the stipulation was actually signed in the sometime in '08, the beginning of '08, where Ms. Edwards and the Campolones engineer and myself and Mr. Sullivan reviewed this and came up with a stipulation which the revised plan would have to comply with in order to be approved by the Township. That stipulation was approved by the Township in March of '08. It was approved by the Zoning Hearing Board in April of '08, and then Ms. Edwards signed off on it at the end of April of '08. When they submitted this plan, they submitted it consistent with the stipulation. Mr. Sullivan and I have reviewed it, and when we use the term stipulated plan, this is a plan that complies with the stipulation. Therefore, they are entitled to what they negotiated back in 2008, and they are entitled to have certain aspects of this plan, the no curbing, for instance, because that was negotiated in 2008, they are entitled to get the benefit of their bargain. And so that is what we refer to when we talk about a stipulated plan. There was a stipulated settlement, and they have submitted a plan that complies with that stipulated settlement.
Okay. All right. And you said earlier that the plan was, stipulated agreement was approved by the Township in, I think you said March of '08, or April of '08, March of '08, I think you said, correct?
My signature on the stipulation is in March 8th of 2008.
Right.
And so I assume, March 4th, excuse me, of 2008, and I assume we did it somewhere around that time. Zoning Hearing Board did it on the 8th of April in 2008. So they did it after we did.
And obviously, when you say it's approved by the Township, you're referring to the Board of Supervisors.
Board of Supervisors, correct.
Right. So this was an issue that, not necessarily the plans themselves maybe, but in the actual agreement itself was approved, and they've, by this board, except for Mr. Dents, who wasn't here at the time. And then the plan that's submitted is consistent with that agreement that was approved by this board.
That is correct.
3 years ago.
That is correct. And actually, Mr. Dents approved it as part of the
Zoning Hearing Board. That's right. That's right. Not off the hook. All right. Okay. So I wanted to make sure the board members were aware of that in terms of this, the long history of this project, which I think, as you said, goes back to '03, which was even before I was on board. So, all right, that being said, I think we're looking at a resolution which was prepared and does include the waivers outlined and reviewed by Ms. Edwards. The resolution will be 11-3. okay, and would be granting final land development to CVA for this project. Is there a motion at this time to approve Resolution 2011-03?
I'll make the motion to approve resolution number 2011-3 to grant final land development to CVA for the project at the location at 110 Central Avenue.
Okay, motion made. Is there a second?
I'll second it.
Okay, motion made and seconded. Mrs. Poland, can you pull the board, please?
Mr. Zupka?
No.
Mr. Harvey?
Yes.
Mr. Dents?
Yes.
Yes.
Okay. All right, thank you.
Thank you very much.
Okay, next item on our agenda is sort of another little bit of unusual circumstance for us, something else we don't usually do very often. An intermunicipal transfer of a liquor license for 160 Bristol Oxford Valley Road. This is the applicant is Sunshine Valley LLC. For those that are trying to wonder where 160 Oxford Valley Road is, this is the former Wawa building, which obviously the new Super Wawa has been there now, but this is the former one across the street from the where Fuddruckers used to be, that kind of thing. So, Mr. Gray, or actually I'm going to go to Mr. Clark, I guess. This is, I think we've done, one other of these in the time I've been on the board. So in terms of procedures, this is a hearing, basically?
I would ask, yes, it is a hearing. I would ask that you open the hearing, and then I would put certain information on the record, and then the applicant's attorney will be permitted to present evidence in support of his application.
Okay. All right, so is there a motion to open the hearing for the intermunicipal transfer of a liquor license application for 160 Bristol Oxford Valley Road?
So moved.
Second.
Motion made and seconded. All in favor? Aye.
Aye.
Opposed? All right, Mr. Clark.
Thank you, Mr. Chairman. This is a public hearing for a liquor license application. The applicant is Sunshine Valley LLC. The subject of this hearing is the application for an intermunicipal transfer of a liquor license to applicant's business at 160 Bristol Oxford Valley Road, postal address Langhorne, PA 19047. The hearing is being held for the purposes of receiving comments and recommendations of interested individuals residing within the municipality concerning the applicant's intent to transfer a liquor license into the municipality of Falls Township. This application, which was submitted by Sunshine Valley LLC, was submitted on December 8th, 2010. The Pennsylvania Liquor Code requires that the township render a decision within 45 days of the submission of a complete application. We have reviewed and found the application to be substantially complete. While the application does not indicate the proposed name of the business, a review has found that it will be Phillies Steaks and Beer. We have found that the Pennsylvania Department of State's Corporation Bureau lists Phillies Steaks and Beer as a registered fictitious name owned by Sunshine Valley LLC, with a principal place of business located at 160 Bristol Oxford Valley Road. The Pennsylvania Liquor Code sets forth certain mandatory provisions with respect to processing applications for intermunicipal transfers of liquor licenses. Section 4-461B3 of the Liquor Code provides that an intermunicipal transfer of a license must first be approved by the governing body of the receiving municipality when the total number of existing restaurant liquor licenses and eating place retail dispenser licenses in the receiving municipality equals or exceeds one license per 1,000 inhabitants. Section 4-461B3 further states that upon request for an intermunicipal transfer, at least one public hearing shall be held by the municipal governing body for the purpose of receiving comments and recommendations of interested individuals residing within the municipality concerning the applicant's intent to transfer a license into the municipality. We have, my office has contacted the quota department of the Pennsylvania Liquor Control Board. They have confirmed that Falls Township has in excess of one license per 3,000 residents based on the recent census of 2000. Accordingly, the Pennsylvania Liquor Control Board may not approve a new license unless the township first holds a public hearing and approves the intermunicipal transfer application. The township is required to render its decision by resolution or ordinance, and we have provided for the board this evening a copy of a resolution approving the transfer and a copy of a resolution denying the transfer. The application has been advertised consistent with the liquor code on Tuesday, January 4th, 2011, and Tuesday, January 11th, 2011, in the Courier Times. The applicant is represented by Max A. Witowski, Esquire, and he is present this evening along with his client. Mr. Witowski, you now have the opportunity to present the application, any information, any evidence you would like, and any testimony you would like, and then make yourself, and if you have any witnesses here with you this evening, available from questions and from any members of the public who request party status during this hearing. Do you understand those procedures, Mr. Witowski?
Yes, I do. The first thing I'd like to do is submit the certification that the applicant has given notice of this hearing to all property owners within 1/4 of a mile of the premises.
Mr. Witowski, have you previously marked any other exhibits that you plan on
I don't
submitting
have
this
any other
evening?
exhibits.
Okay. So this would be marked as A1 for applicant 1, and this is, again, consistent with the liquor code. The applicant is required to present notice to property owners within 1/4 mile of the subject premise. Mr. Witowski has submitted a certification from a member of Sunshine Valley LLC, and attached to this certification is a list of all properties that from the county recorder of deeds are within 1/4 of a mile of the subject premises.
Okay.
That is correct. My client intends to operate a restaurant at the premises, which is primarily take-out food and take-out beverage. He's going to operate this business, and what he's trying to do now is to bring in a Pennsylvania Liquor Control Board license to be able to sell beer along with the food. It's not an R license, it's an E license with the LCB, which is beer only. It's not alcohol, so no alcohol is going to be sold there. He does not intend to offer any kind of entertainment there. It's strictly restaurant to come in and eat, or take your food and take it home with you. I would like to call Harris Patel as a witness. He's a sole member of Sunshine Valley LLC.
Okay. Make sure, speaking in the microphone. Yeah, thank you. Oh, you had to. Yeah, I'm sorry. You have to be sworn in first.
Do you swear the testimony you're about to give is the truth, the whole truth?
Yes, I do.
Can you spell your name?
Harish Patel, Harishpatel.
Okay. Harry, would you please describe your intended use of the property?
Yeah, it's basically like, it's a small restaurants with the takeout and, a little bit beverages, like only beer takeout and a little bit of sitting area. According to PLCB, we have to have some sitting area inside. But the main thing is for takeout, the restaurant like cheesesteak sandwich and hoagies and French fries and stuff like that.
Okay.
Harry, have you ever had any experience owning a Pennsylvania Liquor Control Board license?
Yes, I do. Yes, I do. I used to own a beer distributorship before, and I have a clean record, no criminal or no citation or anything on the PLCB license.
Okay.
Do you have anything else?
No, basically, that's about it. Thank you.
That's all the testimony we have.
Okay. All right. We'll go to board members for comments or questions for Mr. Rutkowski or Mr. Patel. Mr. Zipka?
No, I have none.
Mr. Snipes?
Actually, a question for Mr. Clark. Could you repeat again the requirements for the intermunicipal transfer of a liquor license? You're saying at this point, if someone were to attempt to acquire a liquor license in Falls Township, is the only way to do this now to buy an existing one that is now located in the township, or to do this intermunicipal transfer?
No, this is actually what is, the Liquor Control Board has recognized that with the buying and transferring of liquor licenses, that some municipalities were getting too many liquor licenses. If you have a liquor license already located in Falls Township, and you want to transfer it to another individual in Falls Township, we are not holding a hearing on that. That is strictly for the Liquor Control Board. This process is involved when you are attempting to bring a liquor license from another municipality into your municipality. If there is more than one liquor license per 3,000 residents in the township. Essentially, what the Liquor Control Board was trying to do was trying to give local government a little bit more control if there were many or too many liquor licenses being transferred into a municipality from outside. And that is essentially what has happened here. What we do in these instances, when an application comes in, we check with the quota department from the Pennsylvania Liquor Control Board. We confirm that we have more than one liquor license per 3,000 residents, and then we're permitted to hold this hearing. So what essentially Sunshine Valley LLC is attempting to do is transfer a liquor license from another municipality into Falls Township. And now we hold this hearing for the board to hear it, and then for residents to also comment.
Okay, thank you. So, do we have more than the more than the regular, more than the average number of liquor licenses in a second-class township of our size, or
Well,
how are we doing? Are we drinking a lot, or or are
I'm
we?
doing the math in my head with a population of roughly 35,000. If we have 12 establishments that have liquor licenses, then that's exceeding one for 3,000 residents. So it's, if you think about the restaurants, no, I mean, they're just not, especially just up here across the street at the shopping center, the Home Depot shopping center. You have a lot of restaurants there that serve alcohol.
Absolutely.
So I mean, I don't know.
And the very real possibility exists that we have more than 12. We may have upwards of 20 or 25. Those may have existed at a time, they may have been originally granted to Falls Township businesses, or they may have been transferred in before this change was made. I can't remember exactly when the change was made, but these transfers may have come in before the change was made, when it gave local government a little bit more control, when the Pennsylvania Liquor Control Board was the only one signing off on them. So what we do know is, I don't know the exact number that we have in the town, but according to Mr. Harvey's math, we probably have at least 12, because we have more than one for every 3,000 residents.
Okay, thank you. Those are the questions I had. Thank you.
Mr. Dents?
No comments or questions.
A question, Mr. Patel, you'd mentioned that you owned a beer distributorship. Do you have experience owning any kind of a restaurant, whether it served alcohol or not?
Not in the restaurant business, but I'm going to hire a couple of people, and I'm going to work by myself over there.
Okay.
Make sure that everything is all right,
Okay. All right.
Thank you.
Okay. And the alcohol sales, the beer sales would be, could be for people who stay, or it's obviously for takeout, but it could be people who just, they get a cheesesteak, they get fries, they get a beer, they sit down. Basically, it could be that too. They don't have to, it doesn't have to be just takeout, correct?
That's correct, yes.
All right, and I think you had said, and I guess either one of you can comment on this, I think Mr. Patel said it, that Pennsylvania Liquor Control Board requires that you provide some indoor seating, is that correct?
That is correct. Seating for 30 people.
Okay, all right. Okay, thank you. So I guess the point was, even if you didn't want to serve, beer to someone to just sit and stay, if you wanted it to just be a takeout place, you couldn't.
Correct.
Okay. All right. Okay. Those are all the questions I had. Mr. Clark, questions from you?
I have none, Mr.
Okay. All right.
Chairman, I would like to correct something. I did misspeak before, because I was thinking of the conditional use hearing. Interested individuals who want to come forward and comment do not have to request party status. That is only in a conditional use hearing. So normally where we close a conditional use hearing and then take public comment, interested individuals who are present this evening are permitted to come forward and comment without having to officially request party status.
All right, that was sort of my next question. Typically now in the conditional use hearing, we would stop the hearing and now do public. So in other words, we do not stop the hearing, we keep it going.
Do not stop the hearing.
Okay. All right, so at this point, open up for public comment if there is anyone interested. I see one hand. Is there a motion to open public comment?
So moved.
Second.
All right, all in favor? Aye.
Aye.
Opposed? Okay. Yes. Just, you have to come forward, ma'am, to the microphone and just identify yourself. You need her to...
She does not, no,
okay.
she does not need to be sworn.
No. Do you need her name, Mrs. Brundle? If you wouldn't mind just giving your name clearly so she can get it.
Marie Krotz, K-R-O-T-Z. I own a Falls Township, Pennsylvania liquor license within a quarter of a mile of the proposed one. And I feel that it'll have a great impact on my beer takeout store. I have a bar, restaurant, and takeout center. And I just feel that we don't really have the need. I really rely on people coming from the other areas and from the hotels and things on the other side of Route 1 to make it today because of the economy being where it is. So that I just found out about I'm very guilty of not reading the Courier. And I missed it until some residents of Oxford Crossing made me aware. So that's why I'm not represented by council or anybody this evening. But I'm here to oppose the grant of a Middletown Township coming into Falls.
Okay. All right. Thank you.
Thank you.
Anyone else wish to speak? See no other hands. Or a motion to close public comment?
Didn't there was another gentleman?
Oh, where?
Did you want to speak? No.
Oh, I'm sorry. I didn't. Okay. No one else then? Okay. Is there a motion to close public comment?
So moved.
Second.
All in favor? Aye.
Aye.
Opposed? Okay. Mr. Clark, I'm going to lead your guidance here again.
The board is allowed to consider the record that is in front of it this evening. You have testimony from the applicant. You have information provided by his attorney. You have comments from one resident, or excuse me, not one resident, but one interested individual who is a business owner who essentially, I think I can sum up what she said by saying that she thinks it will hurt her business and is opposed. In looking at these matters, the Pennsylvania Liquor Control Board does not give municipalities specific reasons for approving or denying. Much of what you are asked to consider is consistent with the decisions that the board makes on a regular basis. Whether or not an action requested by an applicant will have a detrimental effect on the welfare, health, and morals and safety of the residents of the township and those visiting the township. The record is complete in this matter, and I think that the board is free at this time to make a decision without needing to supplement the record. And again, as we said, we have provided you with a resolution approving the transfer and then a copy of a resolution denying the transfer. The applicant, if the matter is approved, it still needs to be approved by the Pennsylvania Liquor Control Board. If the matter is denied, then the applicant would have to appeal the decision of this board. It cannot be overruled by the Pennsylvania Liquor Control Board.
Okay. Okay, so at this point, do we vote underneath the, while the stenographer's still here and the hearing's still
Yes.
open? Okay, all right.
If obviously, if the board would so desire, since in whatever the decision may be, this could involve potential litigation. If the board wished to consult with me in executive session, it could, but obviously any vote would have to be taken in public.
Okay. All right. There's one board member who did inquire about that. I was about to ask that. I wasn't sure if it qualified or not. So
well, I'm assuming, if the board wishes to consider the record that is in front of it this evening, you have testimony from one resident who is a business owner who is essentially, I think I can sum up what she said by saying that she thinks it will hurt her business and is opposed. there is always the potential for litigation in the approving or denying of an intermunicipal transfer. So because of that reason, it could be, would be appropriate for an executive session if the board desired.
Okay. I'm assuming there's other concern for, okay. All right, we'll take a short executive session and come back, and we will vote at that time. Meeting back to order. It's about 8:32. Mr. Clark, can we have a report on our executive session, please?
Yes, Mr. Chairman, the board held an executive session to discuss a matter of potential litigation and to confer with me on matters related to this application.
Okay. All right, so we've heard from the applicant and the applicant's attorney. We're still in the hearing stage. The board has before it, and the board has also had a chance to ask questions, as have professionals and the public. The board has before it two resolutions drafted, one approving and one denying. In either case, this resolution would be 2011-4. So at this time, the chair will
Mr.
enter.
Chairman, I'm sorry, my mic is coming apart. Excuse me, do we have two resolutions? I only see one.
There's one, they're back to back.
Oh, they're back to back, I'm sorry.
Is that the, no, I think that's, you're looking at the other one. You're looking at, let's see.
This is it.
Yeah, this
It's
is
the-
here. It's from this.
Oh,
it's
I'm
a
sorry, this is-
Memo from, like this. It's attached to memo dated January 13th, 2011, from Mr. Clark.
This is it right
There it is. It's
Okay,
right now.
so there are two, okay, one is approving and one is denying, I understand.
there? Yeah.
All right, so, and the resolution states, approving or denying an application for intermunicipal transfer of liquor license into Falls Township of Sunshine Valley LLC, 160 Bristol Oxford Valley Road, Langhorne, PA 19054, 190, excuse me, 19047. Is there a motion at this time in either direction, approving or denying?
What is the number for each of these?
04.
04 is for approving?
Either one. No, either one.
Oh, they're
It's-
both
yeah,
04,
yeah.
I'm sorry.
Yeah, if you're approving it or denying it, we're only doing one of them, so it depends on what motion is made and carries, basically. But is there a motion in either direction to approve or deny?
Mr. Chairman, I'll make a motion to approve Resolution 2011-04, which is the application for intermunicipal transfer of liquor license to Falls Township of Sunshine Valley LLC, 160 Bristol Oxford Valley Road, Langhorne, PA 19047.
And that would be the resolution approving or approving the application? Okay. All right, motion has been made. Is there a second?
I'll second the motion.
Okay, motion is made and seconded. Mrs. Pullen?
Mr. Zucker?
No.
Mr. Harvey?
Yes.
Mr. Dent?
Yes.
Mr. Snee?
Yes.
Okay. All right, at this point, I guess we will have a motion to close the hearing. Okay, is there a motion to close the hearing for the intermunicipal transfer of a liquor license?
So moved, Mr. Chairman.
Second.
Motion made and seconded. All in favor? Aye.
Aye.
Opposed? Okay. All right. Thank you, gentlemen. Okay, next item on our agenda is consider purchase of mobile laptop computers for the police department. Item 5, Mr. Gray.
Yes, the police department is requesting to purchase 6 mobile laptop computers. Cost of the laptops is $18,698.52. This amount has been budgeted in the 2011 budget, and these laptops are also on the CoStar's list. At this time, the board is asked to consider the purchase of 6 mobile laptops for $18,698.52 from Hub Data 911. In addition, Sergeant Harvey Taylor from the Falls Township Police Department is here to discuss this item further.
Okay. Sergeant Taylor, welcome. Sorry to keep you waiting.
Not a problem. I was here last year in front of you gentlemen. We have 18 of these Data 911 mobile computers in the cars. They've been purchased, the first purchase of them was in '04. The final purchase of the last 2 of those was in '07. So these systems now are between 7, well, actually, we replaced 6 of them, so they're gone. But the existing systems are 6 and 5 years old. So my proposal was to replace 6 a year over a 3-year period, and now we're updated again. Hopefully, we won't have to do this again for at least another couple of years with the systems that we purchased. I'm basically here to answer any questions that you might have. The systems that we are replacing still function. They run fine. The problem is they no longer have the ability to run the hardware and the software that we need to run on them now. They're just outdated.
Okay.
So,
all right.
Also, the purchase only includes the actual computer, the keyboard, all the wiring, and the mounting hardware. The monitors, 3 years ago, we purchased upgraded monitors for all 18 of those. So the monitors are going to stay, the existing monitors. This is just for the everything but the monitors.
Okay. All right. We'll go to comments or questions from board members. Mr. Zupka?
Thank you. To me, this is sort of a no-brainer. If we're going to keep up with technology, we just have to do it. And I'm going to say I'm sorry. Sorry we kept you here all evening.
I'm working anyway, actually. So.
All right, Sergeant.
It's warmer in here, right?
Absolutely.
Mr. Snipes?
What happens to the old computers?
Whatever you guys want to happen to them, they're yours. I'd like to keep 2 of them as spares in case something happens. Then while there's about a 10-day turnaround time when I have to send these back for maintenance or for repairs, they're under warranty, and then we buy extended warranties on them, so we don't have to worry about any of the repairs ourselves. Tech support will talk me through a repair if I can do it. If not, then I have to mail it back. They go all the way out to California. So if I keep 1 or 2 of these as spares, then when that one gets sent out, I can at least install one in the car, and we can use one of the older ones that still function. They just don't work the way we need them to. But it's better than down in the car completely. The other 4, I'd like to request to the chief that we keep 2. What they do with the other 4, I don't know. I guess they could resell them. They could donate them to somebody. They could do almost anything with them. They still work fine.
Okay, thank you. That's my only question.
Okay. Mr. Dents?
No, we budgeted for this, and obviously they need them.
Right. Okay. Yeah, I don't have any questions either. I think all of us are pretty familiar with the television shows that are on now, but the laptops being in the police vehicles and really how it helps the officers do their job much more efficiently and keeps them safer too. If they're running a plate, they can see right away if somebody's, how bad a bad guy they might have in front of them. So they know that before they even get out of the car. Are there any comments or questions from the public? I see no hands. Okay. See no hands. Is there a motion then we're looking for, and this is off the co-stars list, Mr. Gray, you said? Okay. So looking for an approval to spend $18,698.52 from HubDad 911 for the purchase of 6 mobile laptop computers. Is there a motion?
So moved.
Seconded.
Motion made and seconded. Mrs. Pullen?
Mr. Zupka?
Yes.
Mr. Harvey?
Yes.
Mr. Dents?
Yes.
Mr. Snipes?
Yes.
Okay. Thanks,
Gentlemen,
Sergeant.
thank you. Have
Yep.
a good one. Take care.
Okay, items 6 and 7 both deal with the Park and Rec Department, and both are connected a little bit. One is authorizing bids for bus service for the 2011 summer camp program, and one is authorizing bids for chemicals, specifically chloride and muriatic acid for the Pinewood Pool. Mr. Gray?
Yes, the first item, this time the board is asked to consider authorization to advertise for the 2011 bus program for the summer camp. The camp is projected to run from June 27th, 2011 through August 5th. Again, at this time, the board is just asked to consider authorization to advertise. In addition, Mr. Reese is here if there's any additional questions.
Okay. We'll take 2 votes on these, but we'll handle them at the same time. We'll do public comment if there's any needed at the same time. Just makes sense that way. I don't know if there's any questions. I know we've done this every year for a couple of years now to go out to bid on these services. If there's any need to have any questions for Mr. Reese. We know the bus services basically takes the kids to the pool usually once a week and then to various field trips. Could be to Philadelphia, could be to Great Adventure, could be Dorney Park, could be somewhere else. So comments or questions from board members for Mr. Reese or I guess Mr. Gray? Mr. Zupka?
No, I have none.
Mr. Dents?
Nope.
I'm sorry, went out of order then. Mr. Snipes?
Did we have an issue with the bids for buses last year? Was it that we didn't receive any bids first time around or something like that? Was that correct, or am I misremembering?
Yes. We didn't have a bid the first time, and the second time we did get a bid.
Okay.
If I remember correctly.
Yeah.
That's the only question I have.
Yeah.
Okay. All right. And I don't have any. Obviously, the chemicals are pretty self-explanatory. Any public comment needed? See no hands. All right, then. Is there a motion to authorize advertisement? Again, we'll do these one at a time. Authorize advertisement of the bid for bus service for the 2011 summer camp program.
So moved.
Seconded.
All in favor?
Aye.
Opposed? And authorizing the advertisement for the bid for chlorine and muriatic acid.
So moved.
Seconded.
All in favor?
Aye.
Opposed? Yeah, Mr.
Thank
Rees?
you.
Thanks. All right, we're up to public comment. We have a 45-minute allotment, and we're going to ask our speakers to contain themselves to 5 minutes each. So we have, first name on the list is, I guess there's maybe two names sort of back to back here. I don't know if it's just one or not. Mr. Kenny and Mr. Mariani are on the same line. Are you speaking together, or are you one after the other, or?
I'll just follow him as soon as he's finished.
Okay. Okay, that's fine.
2 weeks ago, excuse me, Roland Kenny Falls Township. 2 weeks ago, I can't think of John's last name. What's John's last name? Tom. Oh, Mr. Bennett, 2 weeks ago, asked me before we touch any trees on our Ivan Rose property to ask this board for permission to do so. We're looking to take down what's alongside our houses facing Pennsylvania Avenue. Take down them big, dangerous, ugly-looking pine trees and replace them with, can I approach the bench?
Sure. Yes.
Those trees there, I only have 2 trucks. And that's mainly all I'm here for. Because whatever your rule is, we'll do. I'm just tired of fighting over these things. They're destroying our property, and I try to please everybody, and I just can't do it.
Okay.
Okay?
All right. Okay, and it's the particular ones you circled, the cypress ones are the ones you're looking at?
Yes.
Okay. All right. Mr. Mariani, you were going to speak on roughly the same topic, or?
Pretty much the same topic, in a different way, because I'm not here as a spokesman for Avonroe or for anybody on their board of directors. I'm here as a resident of Avonroe, and there seems to be some kind of confusion about these trees and a necessary barrier along Pennsylvania Avenue. Personally, I have always favored having a tree barrier across Pennsylvania Avenue. I have a healthy respect for nature, and look, if it weren't for trees, we wouldn't be here. So let me give you a sequence of events that led up to this. Okay, we'll go back. Well, it's not going to take long, but it does go back a couple of years. Along Pennsylvania Avenue, there were 66 huge, monstrous trees there. Okay, and they were in an extremely confined area, and as a result of that, they were causing mold. We were having constant gutter clogging, ice backed up underneath our shingles. One fell down and hit a house. We're having soil erosion because you couldn't maintain turf there. So as a result of that, we removed 26 of them. This is when I was on the board. But prior to doing that, we sent a letter, and we received a letter from Walter Allman stating that these trees were not on township property. And a copy of that went to Mr. Wayne Bergman, who was manager at that time, and Joseph Arneo. So the trees, as far as they're concerned, didn't belong to them. At that time, I went to the Board of Assessment, and we had a deed search, and the only requirement that I could find was a split rail fence, which was in place and is still in place. Then in February, a letter was sent to all, and I got copies of all this stuff, was sent to all the residents on Pennsylvania Avenue, informing them that we're going to cut the trees down. If anybody has any questions or any objection, please get back to us. Here's the phone numbers. That was followed by another letter prior to the work commencing. If you have any complaints about it, if you don't want the trees cut down, get in touch with us, let us know what your objection is. Prior to commencing that, a letter was sent to Mr. Wayne Bergman at that time to be certain we are in compliance with all township existing codes and regulations. The letter states, prior to commencing the work, we want to be certain that we are in compliance with existing township codes, regulations. Please advise us if, if there's any action we have to take prior to cutting the trees down. Not a problem. We met with Mr. Dave Kerr, and at that time, they didn't have an objection. A letter was sent at that time to Mr. Harkins, who was then interim township manager. That was followed by 2 letters to this board. You were a member, and the only one that wasn't was Mr. Dents. Mr. Propiak was here at that time, and we sent you 2 letters and says, in compliance with township codes and regulations, we removed several trees along Pennsylvania Avenue to correct the problem. So now I believe what Mr. Kenny started, I think it was under the assumption that the same authorization was probably in effect. So, but it was always his intention to replace those trees. Now, I just have some questions here because I'm somewhat confused. What statute or ordinance established this required buffer? I keep hearing about a required buffer, and then I keep hearing people say, well, we had an oral agreement with Traditions of America, who was the construction company, and that would be invalid because any kind of an agreement like that's got to be in writing. Where is this barrier in writing that I can see it, make a copy of it, or read it? Then they say, well, there's a right-of-way. Where's this right-of-way? Is it on Avonroe property? I don't know. Are we adjacent, or are we buffered to these trees, which requires us to take care of these trees? I don't know, but it's just a question. It's a reasonable question. I'd like to know. Does the township have a tree preservation order that we have to maintain these trees? Does the right-of-way have to have trees on it? I don't know. I always thought of a right-of-way a little different than an easement, where you put a physical plan or something. I don't know. And finally, in the letter that was sent to Mr. Kenny, for every tree you take down, you have to replace them with 3 evergreens. Why would you have to plant 3 for every one you take down? I don't know. It's a reasonable question, so I would like to have an answer to those questions without being excessively a burden on any of your professionals. But I really would appreciate that. We do want to be good neighbors to everybody. At least I do. And if this board doesn't want to be a good neighbor, then they'll deal with me too. Okay? Thank you.
Okay.
I can expect an answer.
Yeah, I believe Mr. Gray, were you going to be scheduling a meeting at some point in the near future with, I think, Mr. Bennett?
Yes, we have there is a meeting scheduled with the residents of Pennsylvania Avenue. I believe it's next week to discuss the status of the trees.
Okay, and we can obviously we can schedule a meeting obviously with the people from Avonroe to give them answer some of Mr. Mariani's questions regarding this as well. Okay, so
yeah, if there's an agreement, show it to me in writing, because there's a thing called a statute of frauds, and it's got to be in writing.
Right. Okay.
Thank you.
All right. Thank you. Okay,
Board members.
thank you. All right, next name I have on the list here is Mr. Major.
Yeah.
Good evening.
Good evening.
Hi, I got updates on the tower.
Okay.
For you. I want to give you some.
You've got updates?
Mm-hmm.
Just still waiting for stuff, right?
Like, thank you.
Okay. The first thing in the packet is, and again, this may take longer than 5 minutes. I apologize if it does. Is the Freedom of Information Act.
Mm-hmm.
Okay. Which I don't feel has been really justified for the information that I've been requesting through the township, and as well as Lower Bucks Joint Municipal Authority, which are here for the public. Maybe we'll get back to that. The toxic fumes that we breathe while this tower is being taken down, and again, you guys went out. One of the board members, and I believe the township manager, went out and had an injunction done. I don't know anything else as far as what's being done with the tower, and I think at this point, because we're in direct effect of what's going on with the tower, we would appreciate that we may be included in future meetings with that because of the hazardous materials that were dumped on the property or properties. There's material included in the packets for you as far as torch cutting. The metals, we don't know what metals they are. I'm still not getting any information from the township or Lower Bucks Joint Municipal Authority as far as what the plating is on the tower, and it also covers some extensive information as far as cutting through the paint, which there was 2 layers of paint. My main concern was the plating. It includes all the different types of plating that may or have been on the tower. To this date, I'm having health problems, as well as one of my neighbors from breathing the toxins that came from the tower. I'm not going to get into the details of the health problems.
That's fine.
I just got a bad test today.
That's fine.
Okay, that was the main concern. Second is the toxins that are actually on the property, the properties that connect to the tower. Who's going to test this? I did have a lab out to my property. They didn't test it properly. It's very, very expensive to test this for the toxins, as well as going through all the blood tests and trying to find out exactly what toxins were created from the heating of this material. So that's another issue. I don't know if the township's willing to pay for the testing of the toxins. I don't. Again, I'm not getting any answers. Third thing, excuse me a second. The future of approval of permits for such project, I want to know if that would be addressed with the township, because I think it was just a big blunder for allowing this demolition of this tower, which is a commercial or industrial tower, although I think it sits in non-commercial property. So again, I think that should be addressed in the future as far as I think the engineer had talked about this. He never got them. So as far as the approval of the permits or changes of the permits, again, I did request this information and I haven't gotten any. All the copies of everything that I requested, it's all there. I requested the business license of the demo company. I didn't get it until I simply raised my voice and insisted that I get it. It was here in black and white as far as the information that I did request, and it is public record that I am supposed to get this. They did give me his license after I did, get a little bit more verbal on that. I haven't gotten any permit changing for the site. I was told by OSHA that the site was closed down by the township. I requested documentation as far as how many times the township was out to visit the site, which should have been recorded in some sort of record, that they were actually out to visit the site. Not getting nothing. The last request I made was for material safety data sheets. I did have a phone conversation with the township manager, and he assured me that there is none, at least in record for that the township has. I'm getting the same thing from Lower Bucks Joint Municipal Authority. The reason why I need this is because of the toxin that we may have inhaled. They don't know what to test for. I've already been through so many blood tests, my arms hurt. All the extensive research that I'm doing myself, it gets mind-boggling. If they would simply just give me the material safety data sheets, I can go to a hematologist and get the proper testing that I need. Again, the township manager assured me that they don't have them, but there is information. There has to be information within the records that I'm not getting, and I don't know why that I'm not getting it. I did request.
All right. Well, Mr. Major, I appreciate your obviously bringing this to our attention at our last meeting. However, we are limited in terms of if we simply don't have what you're requesting, we can't give it to you. If this company comes in and is going to be doing demolition, there's certain paperwork they give us, and there's certain paperwork that they don't necessarily give us. And if you're asking for something specific that we don't have, we can't give it to you. We just don't have it. With respect to a lot of the other issues you're bringing up in terms of where we stand, I was going to ask the solicitor to talk a little bit about where we stand with the entire process here with Lower Bucks Joint and this entire demolition of this tank. Mr. Clark, just give us an update.
Yes, Mr. Chairman. Essentially, after this was brought to the board's attention earlier this month, my office filed an injunction against Lower Bucks Joint Municipal Authority and against a contractor. The injunction has not been granted because Lower Bucks has agreed and the contractor has agreed not to do any further work until three areas are satisfied, or 3 areas are addressed to the township satisfaction. The first is we would like information regarding any material that is on the tank, any testing that was done, anything that they have with regards to any regulatory testing or regulatory permits from DEP, OSHA, or EPA. They have told us they will get us that. At this date, we have not yet received it. The second matter is that we need to have a plan for taking down the remainder of the tank in a manner which will not create the problems that were existing before, the blowing of debris and things of that nature. And that plan must be submitted, and it must be approved by Mr. Sullivan. Finally, we have asked for Lower Bucks Joint to submit a plan for the remediation of the neighboring properties, cleaning up any of the debris or cleaning up anything that has blown onto the neighboring properties. And while Lower Bucks Joint is willing to do that, the one thing they are not willing to do at this point in time is they're not willing to say that all things regarding any damage will fall on them, because some of those may need to be submitted as insurance claims. And obviously, we would not be involved in any insurance claims for any damage that may have been caused to any of the properties. That would be up to the individual homeowners. We are mostly concerned with the cleanup of any debris or anything else that may have gotten onto the other properties. At the last check, late last week, we got a letter from the Lower Bucks Joint attorney indicating that they're still gathering all this information, and again reiterating that they won't do anything further with the tank until everything is agreed upon. Judge McMaster in the last conference that was held, told Lower Bucks Joint not to move forward until there is an agreement by the township or he makes a ruling. So that's where we stand right now.
All right, thank you. So I think that addresses a lot of the concerns you had. I mean, obviously, again, we can't turn over any kind of testing to you because we don't have the results of any of it, and whether it's the material itself, the paint, or you know, whatever the MSDS for whatever the torches they're using. When we do have that, obviously, then you know it'll go to the township engineer. He'll take a look at it. He'll start making some determinations as to what has to happen. If the environmental officer needs to be involved, that'll happen as well. And we can certainly bring it to your attention when we get it. But as of now, we just don't have it. And I think the plan, the work that Mr. Clark did, especially you know getting this project stopped. And now setting up these criteria that Lower Bucks Joint has to meet before it continues, I think is a pretty good plan. I would hope that you're satisfied with it, and certainly I'm pretty satisfied. They can't do anything more until we tell them that they're allowed to, or a judge tells them they're allowed to. So that's how we stand at the moment. And as you obviously see, and I see every day, there isn't any more work done. In fact, I think Mr. Clark had heard the crew that was working on that tank almost immediately left for Texas, where they had another tank they had to bring down. And I think from there they're going Colorado or someplace, or New York State, and they were essentially, there's probably one reason why they get so many jobs all over the country. It's probably because they're the cheapest. And I think we saw the reason for that. You know, why the price was so low. So, but again, that's the update we have. Again, we appreciate you bringing it to our attention. And when we know something else, we'll let you know.
Okay.
Okay? Thank you. All right, Thomas Sheedy? No? Okay. Gallus Obert?
Good evening, ladies and gentlemen. Gallus Obert. I listened with amazement to some of the issues that residents have brought up tonight. The two gentlemen from the tree problem and the leaves, you know, when I first moved here in Fairless Hills 50-some years ago, my trees were 3 foot high, 4 foot high. And you stay 30, 40 years, and the trees are now 30 foot high. And the first thing that happens when new people move in is cut the tree down. They don't want the leaves, they don't want this. We wanted shade, we wanted our place to look nice. But if you keep cutting trees down and replacing them with bush, you're going to have a blacktop city, blacktop and concrete. So I don't know how they're going to resolve the problem, but I'm sure those two gentlemen will push it until they get rid of the dirty trees. The gentleman just preceded me. I feel sorry for him with the removal of that tank. I can't believe that tank got removed as much as it did without somebody noticing what's going on. And the Joint Municipal Authority, I can't believe they just let that go. I just can't believe that. My issue tonight is something that has to do with the dredging of the Delaware River, or the basin. The Redevelopment Authority, I don't know how the Redevelopment Authority gets involved in this, but they said they needed $395,000 to dredge this basin at the old USX plant. Bucks County commits to $75,000. Falls Township commits to $75,000. I have questions like, when do we contribute the $75,000? Where's the rest of the matching funds coming from? 75 and 75 is 150. 150 from 395 is 245. $245,000 short. Where's that coming from? We got carte blanche somewhere. There's matching federal funds of $1,200,000. Is the $1,200,000 just for the turning basin? Question. Who's paying for the 40-foot depth around the dock where these ships are coming into? there's so many questions asked. How many freighters a month are going to be coming up to that dock that need the 40-foot depth? Right now it's 35, and plus all the silt that's been built in it. How many companies are really going to benefit and require this 40-foot depth? One company, two companies, three companies, no companies? If the project begins in August 2011, what's the completion date? Now, here's the big one. The Delaware River channel is 111 miles long. When will the ships requiring the 40-foot depth start pumping dollars into the Bucks region? It's been going on for a few months now, and by the time they get started, it'll be another year. I've been fortunate enough to having a campsite on what is called Money Island. I was there when they dredged the river in 1936. I was there when they dredged the river in 1946, 47, 48 for the steel mill. And I've been there before, and I just can't imagine what the heck's going on with this money. It just seems like there's too many unanswered questions. I don't know who to go to. If you want to talk to the engineers, you have to go to Philadelphia. Take the train, go to Philadelphia, walk to City Hall, find yourself a way through there and find out you're the only person there that has an interest. I think the next time we have a hearing, they ought to bring it up here. This is where the people are. Let 2 or 3 engineers travel instead of maybe, I'm sure there's more people interested, but it'd be so much more convenient for these people. So how many years is it going to take to complete 111 miles of dredging at a 40-foot depth? How many companies are going to benefit by it? How soon are they going to benefit by it? And the boats that come in to that port there come in, they're probably about 660 feet long. Okay, they come in, they make a left-hand turn. There's no turning basis, just like a street. You make a left-hand turn and you pull in, and they're nudged into that pier via tugboats. When they go to back down, guess what? The tugboats are there to help nudge it, shall we say, backing down, and they'll back down into the channel. They'll nudge it and make a left-hand turn and go down the river. And I can't see a needing of a big turning basin there. I'm not the river engineer, but those are my questions.
Okay.
But when are we going to give them the $75,000? When is the county going to give them the $75,000? And when are they going to dredge the darn basin? And when are the boats going to start using it? When are we going to see something for this money? $395,000 for the redevelopment authority. I have yet to see that issue. So I leave that with you. I have a lot of questions, as you can see, Mr. Now I'm done.
Okay.
You have some comments.
Yeah, I can answer your questions for you. And all these questions, quite frankly, Mr. Obert, were addressed when we originally raised this issue, and all of it was pretty specific. I mean, Congressman Murphy was even here because he was the one who secured the funding, the federal funding for this project to begin with. In terms of the bulk of the funds are coming from 2 sources, really, Kinder Morgan and U.S. Steel. Waste Management is also contributing, but they are doing the bulk of that almost all of that $245,000. The federal funds, there's 2 issues going on here, which I think you're confusing. There is the dredging of the lower Delaware, which has caused a lot of controversy because people aren't sure where the spoils are going to go. That's totally unrelated to this. This dredging operation you're talking about is only the turning basin. It's not 100 and something miles of river. It's only the turning basin. That's it. And it's basically a one-time dredge to put it down to 40 feet as a turning for the turning of ships. There are already ships that are being turned away. Already ships that have to unload in Philadelphia, and their cargoes have to be brought to wherever they're going to go rather than brought here. that's already happening. I don't have solid numbers on how often it happens or how many ships but essentially Kinder Morgan is operating this facility. It is a facility that brings something in the area of $3 billion, according to the Martin report, into the Lower Bucks economy. Through everybody from working directly at the site to truck drivers that are coming in off of the site. But that was a study done by the Martin report. I believe it was $3 billion. In terms of companies that benefit, obviously Kinder Morgan, as the owner of the port, is going to benefit. Waste Management, U.S. Steel, International Salt. There's a fertilizer company down there too. I can't remember. But essentially, it's an operation that is focused on improving that port, what's called the Port of Bucks County. It obviously is going to benefit anybody that wants to have any kind of business down there. I even relayed the story of when I was in Korea last year, or in 2009, I should say, and a company that was interested in talking about coming to Bucks County, one of the biggest companies in Korea. It was actually a lumber company that buys a lot of lumber from Pennsylvania. And they asked about, we told them we had the port, and I think they had even visited KIPC at one point when they came here. And one of the questions they asked was the depth of the port. And they said, well, if it's not deep enough, we can't come. And it just wasn't deep enough. And so they immediately just said, well, then, maybe we'll go to Philadelphia. Now, they haven't moved here in either direction, but that was an issue, the issue of the depth of that port. So I think those are the answers to a lot of your questions in terms of when it's going to happen. I'm sorry, it was the other one. And when we have to give the money. The project is being, I think, studied at this point by the Army Corps. When the Army Corps gives a go-ahead at that point, then the money will have to come from the different, entities, us, the county, Steel, Waste, Kinder. They'll have to give the money at that point. That could be next month, it could be May, it could be June. The actual dredging is supposed to begin in August and is only supposed to take a few months. It's supposed to be done before the end of the year. And I believe there's a window in terms of when they're allowed to actually dredge. I think there's some environmental concerns where they can only dredge in between a certain span of time. So that's essentially how the project runs. It's not a very lengthy project in terms of it's not going to take that long to do. It takes longer. I think the actual review process is about 3 times longer than the actual construction. Or dredging in this operation. So, do you happen to have any figures on how many ships a month use that port? I do not. No. Kinder Morgan obviously is the operator of the port. I don't know how many ships they take in a month. I think that would be something that maybe the township would like to follow to help justify this port expansion. What I can tell you is it's going to be the number is going to be less if this isn't done. It's not going to be more. So not doing this project is not going to benefit anything. In actuality, it may even lead to the closing of that port facility. If they can't operate it in a financially advantageous way, they're not going to keep putting money into it. So it certainly, things get worse if we do nothing. Essentially, is what it comes down to. But okay. Well, I still think there's a lot of questions that, in numbers. Okay. Okay. Yeah. When you go through a project, it's how many ships, how deep are they, what are they bringing, where are they coming from, what's going to happen to their discharge water. Okay. Some of the areas in the Great Lakes are getting discharge water, and they're getting sea animals, sea mammals, and so forth into their lakes and their shores, and we sure in heck don't want that in the Delaware River. Right. That's for darn sure. But I just think that maybe somewhere along the line that the township ought to have a folder with all these figures, even if they just get those figures from the Army Corps of Engineers, which you might as well talk to the wall sometimes, is talk to those guys. Okay. I've been down there twice, and it's really a challenge. Thank you very much for the time. Thank you. Okay, those are all the names I have on the list. Anybody else? Okay. All right, move on with our next agenda item, which are the minutes from January 3rd, our reorganization meeting. Are there any comments or questions on the minutes? Mr. Zupka? None. Mr. Snipes?
No. Excellent minutes once again, Mrs. Pullen.
Mr. Dents?
No.
And I have none. Is there a motion to accept the minutes as presented?
So moved.
Seconded.
All in favor?
Aye.
Opposed? Okay, engineers report for January 14th, 2011. Mr. Sullivan, any highlights?
Just the usual highlights, Mr. Chairman. The road program is ongoing at this point. PICO contractor is done with all resolutions to all the service conflicts and the main conflicts. That doesn't mean that during construction we may not hit something else, but at this point, all the ones we knew about since we started the project have been resolved. Storm sewer has been installed on Alden Avenue and on Stevens Road. They're moving on to Oxford Road for storm sewer. They've notified the residents that they'll be working on Oxford Road. They don't plan on doing any curb or actual street work until the weather kind of stabilizes a little bit. The boat ramp is moving along very slowly due to weather conditions, but it's still going to be done before we run out of the constraints on the calendar as far as working in the water.
Okay. So by spring, you're predicting it'll be open?
At this point, the boat ramp will have all the docks installed by the end of April.
End of April. Okay. Thank you. All right. Okay. Any comments or questions regarding the engineer's report? This is the December engineering report. Mr. Zupka?
None.
Mr. Snipes?
No, Mr. Chairman.
Mr. Dents?
No.
No. And I have none either. Okay. Is there a motion to accept the engineer's report?
So moved.
Second.
All in favor? Aye.
Aye.
Opposed? All right, bill list for January 18th, 2011 is in the amount of $1,557,332.52. A look at the bill list will note that with insurance, salaries, and with the real estate taxes that we are paying for the fire companies and rescue squads, of that 1.5 million, almost 1.1 million is with those three items: salary, insurance, and taxes for the rescue squads and for fire departments. So obviously leaving around $400,000, and obviously a considerable amount of that is for the projects that are ongoing in the township road program as well as the boat ramp. Believe another $24,000 is from escrow, which is money that developers put in, so it's not township money. And also highway aid money, which is money from the state, is another $29,000. So, comments or questions regarding the bill list? Mr. Zupka?
None.
Mr. Snipes?
No, Mr. Chairman.
Mr. Dents?
No.
And I have none. All right, comments or questions? See no hands. Is there a motion to accept the bills or pay the bills, basically $1,557,332.52?
So moved.
Seconded.
Motion made and seconded. Mrs. Pullen?
Mr. Zupka?
No.
Mr. Harvey?
Yes.
Mr. Dents?
Yes.
Mr. Snipes?
Yes.
All right, move executive session. We've had that earlier to deal with the liquor license transfer. Manager comment, Mr. Gray?
Yes, just a few items tonight. First item, the township received a proposal for consulting services for the police pension plan from Thomas J. Anderson Associates for the year 2011. Anderson has been the township's police pension consultant for many years. The current rate Anderson is proposing is $4,500. This rate has been the same for each year since 2003. At this time, the board is asked to consider Anderson Associates for consulting services for the year 2011 at a rate of $4,500.
All right, comments or questions for Mr. Gray regarding this expenditure for the police pension? Mr. Zupka?
None.
Mr. Snipes?
What is the scope of their work, Mr. Gray? Just remind me of what they'll be providing.
Anderson Associates assist the township in audits with the state for the pension plans. They also assist us if there's any questions concerning the pension plans regarding our police officers. They assist us with the reporting, the AG 385, pension calculations, if there's any questions on that, or any other Act 600 questions that may arise.
Okay, thank you.
Mr. Dents?
No.
And I have none. Any public comment needed? See no hands. So motion to authorize the expenditure of $4,500 for Anderson Associates for the police pension plan for 2011.
So moved.
Seconded.
Motion made and seconded. Mrs. Pullen?
Mr. Zupka?
Yes.
Mr. Harvey?
Yes.
Mr. Dents?
Yes.
Mr. Snipes?
Yes.
On Tuesday, January 11th, the township declared a snow emergency for the township starting at 10 p.m. that Tuesday evening, continuing until Wednesday evening, January 12 at midnight. By declaring this, the township snow trucks would be able to plow all the roads in the township without cars parked on the streets. Per the Township ordinance, the manager may declare a local emergency subject to ratification by the Board of Supervisors within 7 calendar days thereafter. At this time, the board is asked to approve this action imposed by the Township manager.
Okay, I don't think there's any comments or questions on this. Is there a motion to ratify the state of emergency, which was in effect last Tuesday, into Wednesday, January 11th, 12th?
So moved.
Seconded.
Motion made and seconded. All in favor?
Aye.
Aye.
Opposed?
Just one last item, just an announcement from the Park and Rec Department. There will be a special meeting for the annual pasta dinner run by the teens on Monday, January 31st at the Township Building, starting at 6:30. This will be held in the public meeting room. Anyone interested in volunteering their time for the annual pasta dinner can attend this meeting. During this meeting, there will be discussion on setting up committees, work assignments, times of the event, and select organizations that will be receiving the proceeds. The tentative date for this event is Sunday, March 27th at the Falls Township Senior Center main building from 4 p.m. to 7 p.m. If you're interested in participating in this annual event, please call the Falls Township Park and Rec Department at 215-949-9000, extension 220, 221, or extension 222. That's all I have.
Okay. Thank you, Mr. Gray.
Thank you.
All right, we'll move on with board comment. We'll begin with Mr. Snipes.
No comment this evening, Mr. Chairman. I'm a little under the weather, so I think it's better if I don't talk. Thank you.
All right. Mr. Dents, moving to you.
A couple things. One, we received a letter of interest for an appointment to the Zoning Hearing Board from Thomas Miles, who's a Falls Township resident. I've known Tom for a while. He's very qualified, obviously, with his education background, his work background. Him and I actually attended a couple zoning board meetings together, give him a taste for what it was going to be like. And with that, I'd like to nominate him for an appointment to the alternate position on the Zoning Hearing Board.
Okay.
You making a nomination?
Yeah.
I'll second it.
Okay, motion's made. And this would be a resolution 2011-05, right? We have to do by resolution. All right, so it would be 2011-05, and it would be for a full term, I believe. Is it full term, or is it? No, because I think Mr. Kiernan.
3-year term expiring December 31st,
All right.
2013.
Okay. All right, so it's a 3-year term because the previous alternate moved on to the zoning board, so he had a full term, but he served a year, now he dropped off. So, okay, and just you mentioned Mr. Miles's qualifications. He's an electrician as well as graduate from Bucks County Technical High School, where he majored in civil engineering. So obviously that kind of background is useful on the zoning board. All right, so there was a motion and a second for Resolution 1105. So no public comment needed. I know Mr. Miles is here.
Looks like your brother.
We'll
He looks like he's related to you.
It might be an insult. Might be an insult to one of them. I'm not sure.
Everybody.
Not sure how much of an insult that is to somebody.
I thought it was a relative came sat in.
Mrs. Pohl, could you pull the board, please?
Mr. Zapka?
Yes.
Mr. Harvey?
Abstain.
Mr. Dents?
Yes.
Mr. Snipes?
Yes.
For the record, in terms of abstention, Mr. Miles is actually, I think it's third cousin, so might be somewhere in there. He's part of the family, so
It's a big family.
might be
trait.
another insult. I'm not sure which one. Yeah.
No.
All right, and let that not sort of disqualify him for any position on the township. No guilt by association. Okay. Anything else, Mr. Dents?
We talked about the PSATs coming up and my availability, and I am available.
Okay. All right, then. Someone would then make a motion to nominate Mr. Dents as the official representative to the PSATs convention.
No way.
Moved.
I changed my vote. Yes.
Motion by, not feeling too under the weather, obviously. Motion by Mr. Zepka, second by Mr. Snipes.
Oh, okay.
All right. Motion second. All in favor? Aye.
Aye.
Opposed? I can vote on this one. Mr. Dents is not related to me. So, anything else?
That's it.
That's
all
it?
for tonight. Think spring. That's
Think spring.
25 days till pitchers and catchers report, which is officially the start of spring, I think.
Mr. Zepka.
We've been getting hit with some storms lately, and I think again our public works people have been doing a great job, and I'm not sure our residents really see the picture. You know, they're asked to move their cars off the street, not have them on the street. It really does speed up and make it much easier for our public works people to get out there and get the and to get our streets open and get them clear. But it seems like in the past, in my opinion, the past a year, I'll say, our residents really have been making the effort to work with the public works people. I've even seen some of our residents out there shoveling out around fire hydrants, and even where some of the crosswalks would be. They're opening up the at the curb where so people can actually cross without having to climb through the snow. And it's kind of hard to believe with the cold weather we've had, and we didn't have a January thaw, that the talk of global warming. It's really hard to believe that there is such a thing at this point. But Hurricane Schwartz definitely sent us down the wrong trail with not having these storms, and unfortunately it looks like we got 2 more coming up in the next 10 days or so. But that's all I got. Thank you.
Okay, thank you. One other appointment I'd like to ask the board to consider. Ms. Lindsay Kelly has been a member of the Park and Rec Board for a little while now and was very active in the township, and she has submitted a letter asking to be reappointed to the Park and Rec Board. And so I'll make the motion to appoint Ms. Lindsay Kelly to a full term on the Park and Rec Board.
Second
the motion.
Motion made and seconded. All in favor?
Aye.
Aye.
Opposed? And I also want to note, staying with that board, a letter from Michelle Sheeter, who has been on the Park and Rec Board for 10 years, and announced that she, her term has expired, and she did not wish to be reappointed for some personal reasons. And I want to point out, for those who might not know, the skateboard park, which is becoming increasingly popular. Even hearing people from who've been in places in New Jersey that, kind of overhearing people talking about, if you want to go somewhere really good and skate, the best skate park in the area is Falls Township in Bucks County in Pennsylvania. That's something that's, very impressive. And Michelle Sheeter really was, more than almost anybody else in this township, the driving force to make that skateboard park a reality. More than certainly the board members up here, she did a tremendous amount of work, research on her own, really driving this project. Even when budgets got a little tight and they got put on the back burner, she was always pushing for it to get done. And so anybody that goes down there and skates really owes her a debt of gratitude. And so I really want to recognize her and thank her for all the tremendous amount of work that she did, not just on that project, for and all the things that the Park and Rec Board did, and thank her very much for her time. And wish her the best, and perhaps in the future she might have some time to dedicate back. Not that she needs to, but I know she's very, very good at it. I know she likes doing it, so we'd always love to have her back. So I just want to recognize her for all the work she did. And lastly, I want to ask board members to consider our open space plan. Our Township Open Space Board did meet and submit a report to us last year outlining some properties that they felt, and prioritizing them, that they felt our open space money could be spent on. The township has, thanks to the county program, in excess of $900,000 to spend on open space in the township. And I'd ask board members to take a look back at that list and the report. It was approved by the Bucks County Open Space Committee as well, so we know that they're in favor of it, and we're at the point where we can actually spend money, and the real estate market obviously is probably in our favor at this point, being it's sort of a buyer's market. So we'll look to maybe do some of that in the very near future. I want to remind people to sort of to stay on top of that issue. All right, and that's all I have. Is there a motion to adjourn?
Make the motion to adjourn.
Second.
All in favor?
Aye.
Opposed? Thank you.